it's a difficult path to follow. And this court would be entering into the terrain of political rights, number one. Number two, the MPs are in parliament because of the confidence the electorates have on them. That vote for yea or nay represents, or it's a mandate that is carried from the electorates. So in other words, you would invite us as the court to look at the issues de novo and say, you may have voted the way you did. We don't think you voted correctly. We think this is the correct way to vote. Or you go and vote again. I don't think we can do that. I don't think we're competent to do that. This is the will of the people. The people at that time were the ANC, which had the majority vote. I'm not sure we can do that. And I'm also not sure whether there is any evidence except the pronouncement made by Chairman Mantashe when he says, ask or check what Makosi cost.
Yes.
But that's
Justice Matopo, may I just start with the second argument, the second proposition first, which was about democratic will, and that the court must have some restraint in engaging that where there's an expression of democratic will. You'll remember that that argument was tested in the SCA in the Delil matter, which was one of the first matters where parliamentary proceedings were subject to constitutional control. And one of the arguments that was raised by and I speak subject to correction, but by Ms. Delil, was that if she was subjected to disciplinary measures inside the House, that which would have the consequence of her being excluded from participating and sitting as an MP, that would have a political consequence for her voters because it means they would effectively be unrepresented. And that's the other side to the coin of the way in which you've constructed democratic will for me. And that argument was rejected in terms because the SCA said that even though that consequence may be whatever that consequence is, i.e. that an MP elected by certain voters might not be sitting in the House, that does not change or derogate from the court's obligation to make sure that when Parliament engages whatever it does, be it a disciplinary measure or an internal procedure, that it does so for lawful reasons. So we would say that the response to the political will argument is the lawfulness of the reasons relied upon to take that particular decision. And if unlawfulness can be founded, then that's sufficient for the court to intervene and invalidate.
But let's not lose sight of the fact that the vote was underpinned by a report which the majority of the members of the National Assembly thought it was fundamentally flawed.
Yes.
They exercise a proper discretion, according to them, to say, we are not being dictated upon. We have seen, we have read the report, we think the report conflates, and they listen to their parliamentary leader, former Minister of Justice, who explained to them what the report was in essence saying. And they said, okay, we agree. And it's not like they just followed that mechanically. They exercise their mind. It's different from the Delil scenario. I think Mr. Katz must have appeared in Delil.
That's right. I think that's right. Now, with all due respect, I would disagree.
You can disagree.
Yes, and I think you know the contours of my disagreement, which is that the principle that was upheld in Delil is that unlawful conduct by Parliament, even if it results in individual MPs being prejudiced, with the further consequence that that individual MP's voters